Looks like Commissioner Pitla is connecting.
And we are all set to call the meeting to order.
Looks like
Thank you. My name is Mark Kimball. Chairman Meyer is unable to be with us today, so I will be acting temporarily in his absence. Agenda item number 1 is the call to order. It's 9:30 a.m. on January 19th, 2023. I call this meeting of the Citizens Clean Elections Commission to order. I'd like to ask all audience members to please keep their microphones on mute, please. And with that, we will take attendance. Commissioners, please identify yourselves for the record.
Commissioner Payton,
Commissioner Chan,
Commissioner Titla, are you here? Commissioner Titla, you appear to be on mute.
Yeah, I'm here. Thank you. Good morning.
Okay, thank you. And I'm Commissioner Kimball. We have a quorum. Item number 2, discussion possible action on meeting minutes for December 15th, 2022. Is there any discussion?
Mr. Chairman, I move that we approve the minutes as written.
Thank you, Commissioner Chan. Is there a second?
it's Commissioner Payton, I'll second it.
Thank you. We'll do a roll call on this. Commissioner Chan,
I vote aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and Commissioner Kimball, I vote aye. The minutes are approved. With that, we'll move to item 3, discussion possible action on the executive director's report. Tom?
yes, thank you, Chairman and Commissioners, and Happy New Year. Although I understand that's already, according to Larry David, it's too late to say Happy New Year, but nevertheless, Happy New Year. Before we start the executive director's report in earnest, I wanted to ask Avery if he could to read an acknowledgement he wrote about Mel Hanna, who is a colleague of Avery's, and I would like to go ahead and, with your permission, Mr. Chairman, have Avery do that, please.
Of course, Avery.
Chairman, commissioners. I just want to take this moment to acknowledge the passing of our colleague in public service, the Honorable Mel J. Hanna. He was committed to serving the public, which was evident from the many positions he held in civic leadership. Mel Hanna became the first African-American elected to city council in Flagstaff, and also to serve on the Coconino County Board of Supervisors. He championed civil and voting rights throughout his career. Mel will be remembered for his devotion to Arizona, community involvement, his pleasant personality, and ability to break barriers. Although his absence is real and a tangible loss, his legacy will live on through the many individuals he inspired to become civically engaged, including myself. If you would like to know more information about Mr. Hanna, you could actually go to our website, azcleanelections.gov, and look at our civic storytelling, where he basically told his autobiography. And it was a privilege to work with him. Thank you.
Thank you, Avery. Very, very touching comments. Tom?
Yes, thank you, Mr. Chairman. Thank you, Avery. Just a real quick update. Obviously, we did complete the recounts in the 3 races that had recounts. As noted in the election, the litigation section, there's still an appeal related to Kari Lake's election contest, and there is a kind of a motion for rehearing pending in Mojave County related to the Abe Hamadeh and his election contest. That said, we are on to the next consolidated election date in March. The principal, and by the time we next meet, the voter registration deadline for that election will pass. And for the biggest race there is the city of Phoenix has a runoff election for 2 city council seats. So Phoenix being the biggest city in the state, that's a pretty big deal. Notwithstanding the holidays, the voter education staff continued to work on the website, and we've done some additional subject matter expert videos, which is something we've been doing over the course of the last year or so. So those will be debuting soon. We have one, for example, on sort of lobbying 101 that we think will be helpful to folks. And then we'll be working on our voter education strategy for this year next, coming up here in this month. We've continued to do a lot of outreach. Gina will be attending the National Association of Election Directors Conference next month, which is exciting. That'll be the second time been there. I think so that's a good thing. We're continuing to work on getting the office where I'm currently sitting up to a place where we can use it better. And then we have audits on this agenda. A couple quick things on the legal front. We'll talk about the Legacy Foundation case and the Center for Arizona Policy case later in the agenda. The Court of Appeals issued an opinion yesterday affirming, a vote by mail against a constitutional challenge. And then a couple of other quick things I would like to mention. The Maricopa County Recorder, Stephen Richer, released a plan for election reform last week. It's got a couple of interesting ideas. It's kind of couched as a discussion document in the sense that I'm not sure that I wouldn't necessarily describe it as pinning down a specific policy that he sort of written in a sort of like list of options, if you will, this would, and the trade-offs within those options. So for example, on the speeding up the vote count, the issue there, and has been forever, is so-called late earlies. That is to say, people who got mail ballots and dropped them off on the day of the election. So the range of options there go everywhere from essentially stopping that to a variety of different, ways of making that more practical, because those affidavit envelopes then need to get signature checked, and then those ballots get counted. And so that's a big part of that. There's also some discussion of adjudication of voter intent. This is an interesting aspect of it. If a voter has, let's say, spills coffee on their ballot and the ballot is not clear as to what it says, certainly in Maricopa County, and generally speaking, there's an obligation to try to determine the voter's intent for that ballot. Now, in other states, as the recorder's report points out, that's simply not done except under very narrow circumstances. And so again, that would be he's laying out a range of options, some of which would be significant changes. And he's also points out that in his view, there's not standardization between counties on how those kind of voter intent issues are resolved. I'm not really here to sort of talk about the merits of his ideas as much as to make sure that everyone's sort of aware that these are discussion points he wants brought forward, and this relates to a couple of other things. I think a couple other interesting things were, and these two are the key for clean elections purposes. One, he thinks there maybe ought to be a new entity with auditing power to enforce campaign finance law. Obviously, he didn't mention clean elections in his discussion of campaign finance law. I'm not sure if that's out of, so we may have some education to do with him in terms of what we do and the range of laws that we do enforce and the scope of that authority. But it was interesting to see that noted. And then the other one is moving the primary data. Many, many years of politicians on both sides of the aisle have wanted the primary data moved up. the primary date moving up is a very, very important thing for clean elections because it is tied directly to the value over time of the money that clean candidates receive. So if you were to move the primary date up very far, you might change change the time frame to collect and get your signatures in. And you might change how that money is necessarily supposed to last. On the other hand, maybe it would benefit clean candidates to the extent that we have a court opinion that says that party coordinated communications with clean candidates are a-okay. The parties have not, for some reason, taken advantage of that. You saw that critically, frankly, in the superintendent's race this year. The Democratic Party did not do coordinated communications with Superintendent Hoffman for some reason. So, but that exists. So maybe there's a balance there, but it's important we keep our eye on it because it moves all of our timelines up and does have an impact potentially on the dollars. Additionally, on the election proposal front, Governor Hobbs announced an executive order creating the Governor's Bipartisan Election Task Force. That study will make recommendations to strengthen election laws, policies, and procedures in the state of Arizona. It incorporates certain requirements on the membership, including the Secretary of State or his designee, allows for the appointment of the nomination by the Senate President's House Speaker of recorders they might be interested in. It calls for a person who's involved in who knows campaign finance, and then which I think is notable for commission perspective. And then the other thing I think that's notable is that one of the goals is promoting transparency, public confidence, and engagement in the electoral process. Which, I'm certain the people who drafted it didn't have this in mind per se, but that's pretty much what the charter of the Clean Elections Act says. So we'll see how that goes. I did want to note that Secretary of State Fontes has announced that Colleen Connor, who was the first executive director of the Clean Elections Commission, has been appointed as election director. I think I can also say, because it's been reported now, that Commissioner Chan will be staying with the Secretary of State's office. So that's a good thing. Certainly not a bad thing. And that's sort of where we are at this. So there's a lot going on, despite the fact that in theory between this December and now, in some kind of way things slowed down, but in many ways they did not slow down. So there's a lot of information we'll be covering, and a lot of activity, and then on top of that, I almost forgot to mention somehow, the legislature is in session. Attached to the report is the county association's legislative principles for this year that includes their election related principles. We haven't yet seen the bill draft for usually the county brings forth a omnibus election bill, and I expect that will happen again this year, but I haven't seen the text of that bill yet, and I don't think it's been introduced. So sorry, that was a little bit lengthier of a report, but I don't know if of course, obviously, Mr. Chairman, Commissioners, if you have any questions.
Are there any discussion or questions from the commissioners?
Mr. Chairman, I wanted to comment.
Commissioner Chan?
Thank you. I wanted to comment on Recorder Richard's proposal. Tom flagged for us that there's a section on campaign finance reform, and frankly, it's just not even a page long, but just a quote. The very first sentence says, "Our current campaign finance system is weak." And it goes on to detail why Recorder Richard believes it's weak, and I agree with him. And I do think that was an oversight not to include clean elections. I know Recorder Richer is a local election official. And so, but I think, you know, to the extent that his proposal gets legs and there might be legislation to address some of the issues he is trying to draw light to, maybe clean elections could be a part of that. I think from a commission perspective, it makes a lot of sense because we already have some enforcement authority and frankly have the staff and resources to do investigations if that's what the legislature decides to enable. And I know I may be getting ahead of things, but you know, just having worked with the campaign finance laws, we have them and they should be meaningful, but it is difficult as a filing office, I think, for anybody local or at the secretary's office to be aware of everything. And unless somebody files something with your office. So I think, you know, the proposals laid out by Recorder Richer are important to consider, but I think that was an oversight that probably should, you know, the commission should be a part of that conversation.
Commissioner Chan, I totally agree with what you say, and those are very good points. And kind of along the same lines, I was going to ask you, Tom, on the governor's task force. You say the order includes certain requirements on members and allows certain officials to make nominations. How can we get also involved in this task force?
Mr. Chairman, that's a good question. Our sort of staff view on this is kind of to wait and see. We are very interested in if the task force, for example, were to decide to, which it could decide to, the governor could decide to subject it to the open meeting law. It's not mandatory. You know, we would obviously attend and be very curious what they are going to do. It's not super clear outside of the specific nominations that are called for by the order, which are the speaker, president, and I think there's a place for an organization recommended by a member of or an organization associated with the disability community, or the big three, in terms of getting an actual nomination. It's not super clear what that process is going to be. We've been, you know, it's sort of one of these things where my experience tells us that if we're going to be asked to participate, we're going to be asked to participate. And if we're not going to be asked to participate, we're not asking to participate is not going to change that outcome. And it might be seen as annoying. That's sort of our analysis. There are ways this could go that would be great. There are ways that it could be, you know, you never know. I mean, you know, so I guess my point is that our current staff viewpoint is monitor. You know, if a commissioner, especially if a commissioner, which is different than staff member, obviously, wanted to be involved in it, that's a conversation we can, you know, I'm happy to have with anybody who wants to be connected with that. You know, obviously, at any moment, it wouldn't shock me if the governor's office were to call up and say, please send us someone. But again, it's you know, the other issue with the approach, and this is just my own, this is sort of, it is the transition is still an ongoing process and evolving, and it's not super clear. I mean, I'll just put it this way. You know, I've reached out to a number of different election officials and people involved in elections through the nonprofit world, and no one has a lot of information to go on as far as, you know, what the intended membership of this will be. So
Okay, thank you. Is any other discussion or or questions from commissioners on Tom's executive report? Hearing none, we'll move on to item 4, discussion possible action on the Arizona Supreme Court supplemental briefing order in Legacy Foundation Action Fund versus Clean Elections CV-22-0041-PR. This item is to update us on a long-standing case, and I would add long. This is the second time Legacy Action Fund versus Clean Elections has been at the Arizona Supreme Court, and following the November oral argument, this week the court issued an order for supplemental briefing on a particular issue that appeared to come up in oral argument. Tom's going to give us some additional background. Mary O'Grady, as you can see, is available if we have questions or if we want to go into executive session or need to. Tom?
yes, Mr. Chairman, commissioners. So yes, just by way of further background, the Legacy Foundation Action Fund matter arose initially in a 2014 complaint, which I believe only Commissioner Titla was on the commission at the time of that particular, and given all of your long tenure, that's remarkable. The matter concerns whether or not a particular advertisement was expressly advocated for or against the defeat of a specific and clearly identified candidate. Now, the issue has gone through the appellate process, has gone through the judicial process 3 times, gone through the appellate, all the way through the appellate process twice, principally because Legacy Foundation Action Fund, when the commission issued its order against them, failed to abide by the statutory timeline to appeal that order to Superior Court. Then that's undisputed and never has been in dispute. That went all the way up to the Supreme Court on a direct appeal from our motion to dismiss the case on account of that. Following that, when we went to enforce our order in court, they filed essentially a counterclaim in the form of a special action that said, no, the commission lacks subject matter jurisdiction, which is, a legal term of art, essentially meaning this issue is outside of the conceivable jurisdiction or power of the commission to have a role, and that issue, it doesn't matter when you bring it. You don't have to follow timelines. You can just bring it when you want to bring it. That issue went up through, we were successful at Superior Court, went to the Court of Appeals, we're successful there. Petition for review, we had the oral argument. The issue at this point that was presented to the Supreme Court was whether or not a section of the restatement. So the restatement, a restatement, especially for, Commissioner Kimball and Commissioner Payton and anybody who's watching, is an effort by a bunch of lawyers and law professors to get together and write what the law ought to be. And then state courts, especially around the country, then adopt these principles, which come through the common law as the rules of the road for the state. And so, you have a restatement of contracts, you have a restatement of torts, and those sort of changes tend to standardize the practice in certain areas of law across the nation. So the question presented to the Supreme Court was whether or not a specific restatement having to do with judgments, that is to say, in this case, the Commission's order to this group to file their reports and pay a fine, should apply or not. Should the court adopt that? Well, at oral argument, a sort of a different question came up around whether or not there was some issue in the administrative adjudication itself that interacted with the restatement in a kind of way and might be outcome determinative. And that's essentially what the court's order said. The court's order said an event may have occurred in this adjudication. We're not sure how, if that event occurred, it would affect our analysis under this restatement section. So please provide us additional briefing on that. They also, and I think this is part of the reason we made this an agenda item instead of just an executive director's report note. They invited further amici, so further folks to file new briefs on this issue. And they invited the Attorney General's office to file a brief itself. They expressly invited the Attorney General's office to weigh in here, which is sort of standard practice at the U.S. Supreme Court, but is not standard practice at the Arizona Supreme Court. And it's less in supplemental briefing orders after all arguments are not. I mean, again, just to put this in context, this doesn't happen very often, and including a specific invitation to the Attorney General sort of raises it to a level of seriousness that, we felt it was important to, we're not in a position to prognosticate about it. We are in the process of drafting our briefs and working with, folks to make sure we have a response ready, but we want to make sure that because it involves so many different moving and complicated pieces that you were aware of it. Mary, I don't know if that was sufficiently. If there's anything I need to take back, first, please let me know. But then second, obviously, Mary, I don't know if there's what else we want to add.
Mary?
Thank you. I don't really have anything to add unless there are questions. I guess I'll add the briefs due next Friday, and all briefs, amici and the commission's brief, and then there's an opportunity for the parties to respond to any amicus briefs, and they have a week to do that, February 3rd. And so after that, then it's back to the court to get a decision, because we've had argument and so we're happy to answer any questions.
Okay, any commissioners have any questions for either Tom or Mary on this issue? Tom, I'm a little unclear. What do you need a motion from us or something, or this is just informational?
This is really informational in the sense that, but because it involves it involves a case that, again, not a lot of you were here for the initial aspect of it. It involves a case that, because of the invitation to the Attorney General's office, has a bit more seriousness to it. My principal concern in making an agenda item was to say, look, if something spins out of this that is unexpected, I want to make sure that that everybody understands who all the players who've been invited to be involved in this process are, and that whether or not this will have, and then the other reason is to be aware that we work, as you all know, we work very hard to keep our enforcement actions in context of our ex parte rules, and ensure that, so there's many things that we may or may not do in enforcements that we may or may not ever brief you about. That's part of the issue that's in this case. And so it's important to, again, to just highlight that the way we do things, at least at Clean Elections, in our view, is consistent with the issue that we are dealing with in this case, which has to do with whether or not the specific issue in the order, if you read it, was, did the commission somehow have an unnecessarily advocative role in the adjudication itself? And as you all know, and I, when we do hearings in front of you, we follow these ex parte rules. We have the other side has lawyers. We have separate counsel from the AG's office that comes in to advise you on your role. We take all those steps in view of the due process issue this order asks to be briefed. And so it's also just an opportunity to reiterate that we are, at least as staff members and certainly in you all as commissioners, are pretty, are stuff that sort of happens without us having much of a discussion about it because it's just how the rules work and how we have the how it's organized. You know, this is sort of highlighting one of those kind of things.
Okay. Absent any other comments or questions from commissioners, we will move on. Item 5. Discussion possible action on Center for Arizona Policy versus Hobbs in her Secretary of State role, CV 2022-016564, Superior Court for Maricopa County, challenge to the Voters' Right to Know Act and the Commission's legal positions and filings. This item relates to a lawsuit challenging the recently enacted Voters' Right to Know Act on state constitutional grounds. You have in your materials the complaint and motion for preliminary injunction. Tom and Mary are here, as you know, to give us an overview of the litigation. We may want to go into executive session at some point. Mary and Tom, if we reach that point, would you recommend, would you let us know if we should go into executive session, please? Tom?
Sure. Yes, Mr. Chairman, Commissioner. So in December, the Water Institute filed on behalf of the Center for Arizona Policy, the Free Enterprise Club, and 2 anonymous plaintiffs, a state constitutional law challenge in state court to the Voters' Right to Know Act, which became effective on the date of canvass. The upshot of the complaint is that there is a state constitutional right to free speech that the Voters' Right to Know Act on its face violates by requiring, in certain cases under certain spending circumstances, people to disclose the original source of funds that funded a campaign ad. It also argues that under the state constitutional right to privacy, that information related to, for example, in the case of the 2 identified plaintiffs, information concerning their donors, and I guess they're sort of standing in the shoes of their donors information. They have a privacy right to how they spend their money on politics. That is driven by the vehicle with which whom they give that money. And then I think finally the third big one is sort of an argument that says that the voters cannot delegate to an administrative agency any authority to make rules, and maybe the legislature can't either. But it's I think pretty broad. It's a pretty broad sort of statement saying, essentially that these are legislative decisions, and they cannot be given. The decisions involved in implementing this act are not decisions that can be left to an administrative agency. So those are I think the big claims. We have, I believe, a briefing schedule set. Staff has been working with Mary on a substantive response. In other words, under the act, at least it's my view, and I think that the expectation is, given this pass with 70% of the vote, that it ought to be defended by someone, and the commission is probably the best party to do that. So we have been working along those lines towards filing a responsive document. We have not, but that timeline hasn't lapsed yet. There is also going to be at a minimum intervention by the Political Action Committee that sponsored this measure at the ballot. And then, we don't know, sort of outside of that, there may be other folks. As you see, as Chairman Kimball noted in the caption, Secretary of State's office was named, and so we'll also see, the Secretary of State's office has an option to be involved or not involved as they see fit. The only other, I guess, thing of note is it's a little bit, you might call this a belt and suspenders approach. They sued the commission and they sued the officers of the commission in their official capacity. So all of your names are in the caption of the lawsuit. We kind of don't think that's really necessary, but or particularly meaningful, given that the commission really acts as a body, especially in state court. So that's where we are. I think that to the extent that, Mary, if you want, and Mr. Chairman, Mary, I don't know if we want to talk a little bit about how we're responding and what context we want to have.
I just wanted to make one note, if I may, Chair Kimball, members.
Yes.
We don't have a schedule set yet. We have a status conference with the judge tomorrow morning and anticipate discussing a schedule at that point. And the key scheduling issues are their motion for preliminary injunction, a time to answer or move to dismiss, and then their motion to have these anonymous plaintiffs. I'll also note that yesterday, Attorney Tom Ryan entered a formal appearance for the Secretary of State, so they do have counsel in this matter. And then, so that's in terms of what's on the playing field here. And then if you're interested in further discussion, I'd recommend executive session for that.
Okay, Mary, Tom, do you feel there's more matters we need to discuss in executive session?
Mr. Chairman, my feeling is this. I think that if commissioners have concerns about what our role here is as a legal matter that are part of the question, that are baked into discussing the strategic and tactical decisions that Mary and I are considering, I think that would warrant an executive session. In other words, I don't want to, we are proceeding on a certain track because of the timing of when the lawsuit was filed versus when our meetings occurred versus all the other different conflicting issues. So what I want to make sure that you all have the opportunity to do is to, if you have questions around the strategic and tactical approach that we are currently going to undertake, that would be covered by, would essentially be privileged information. I think that would be that, if you don't, then understand that we are in fact proceeding along the lines that Mary and I broadly identified.
Okay. Any comments from commissioners?
Mr. Chairman, I don't see a need to go
Commissioner
into executive session at this time, especially since they still have to do a status conference and get a time frame.
Mr. Chairman, if I may, Commissioner Chan, just to that point, we are, maybe I should be clearer, we are going into that status conference with the idea we will be filing a response in opposition to the preliminary injunction.
Okay.
Mr. Chairman, I think that's consistent with my understanding of what,
Okay.
the
I just want to make
commission's
sure the record is clear.
position.
Yeah, no, I apologize. I didn't mean to talk over you. I apologize.
Okay. Any other commissioners want to comment on this or feel we need to go into executive session? Commissioner Payton, Commissioner Titla? Okay, not hearing any overwhelming call to go into executive session, we won't. So we'll move on to item 6, discussion possible action on administrative rulemaking and technological issues in the implementation of the Voters' Right to Know Act, Proposition 211. Item 6, the purpose of this item is to give us a basic timeline for rulemaking and other steps aimed at implementing Proposition 211 by 2024. Tom?
Thank you, Mr. Chairman. So I thought about trying to put together a memo, and then I tried about trying to put together a PowerPoint, and then I ultimately decided I would just talk. But so there's really a couple of tracks. Number one, you know, we're going to have to make some rules. The areas we've identified already where we're going to need to make some rules are disclaimers. That is to say, those little things that go on mailers and the thing that's read at the end of a television ad that says who paid for this ad. That's directive in the act. We're going to have to do have to have some kind of rule on that. There's some some definitional tension between Title 16-901 and Section 901 and our definition section on election cycle, those kinds of technical terms that we're going to want to look at. We're also going to want to look at, obviously, the procedures for enforcing this act. The substance of it. I mean, this new act is very comprehensive on the essentially the guts of it, right? What needs to be disclosed and by whom. And we may not have a ton of, we may hear, but we may not have a ton of necessary rulemaking there, but we will have to give some thought to how that process is going to work. And that may not be identical to what we have on the Clean Elections Act side. And it may be, and then we may also finally want to make sure that the Clean Elections Act side and the Voter Right to Know Act side on the enforcement piece, to the extent there can be improvements on the Clean Elections Act side through this, we may want them to match. So what we intend to do is as staff over the course of the next 2 months is really try to drill down on these issues, research them. We will be needing we'll have some legal assistance on that. We'll be doing some outreach to folks that are involved in these issues to try to get some feedback on what they think would work, what they think won't work. Then if we do that correctly by the second quarter, we hope to have some language along, or at least on the most critical issues, in front of you, with the idea that we would have, we're operating the assumption that we do the 60-day public comment like we did in the pre-2018 days, except we don't have to go to GERC, which cuts our timeline down significantly. So, but we want to kind of think through. 60 days is 2 months. 120 days, is 4 months. So we kind of need to just kind of keep in the back of our minds that we need to leave at least 120 days of time for public comment. Because I think my experience with this, we've done some more elaborate rulemakings, and our recent rulemakings have all been pretty not terribly difficult. There are a lot of cleanup, a lot of clarification, but not a lot of interest in the broader regulated community on what we're doing. This hard to say, maybe not so much, maybe more interest than before. And so we will, and in those situations where we've had intensive work, response, particularly from the regulated community, we've always tried to extend as much process time as possible to make sure we get a good product. And in those cases, we have often come to a consensus that, I mean, 75% of the working lawyers, for example, can live with, and 25% of them can't live with the existence of the act. So it's sort of, and I'm hopeful we can get there again. So that takes us. The idea being that by hopefully by November of, at the latest, we have a good sense of what the regular community has a good sense of what to expect. And then, in the event that, for example, we were not unanimous or the commission chose to set a date for effectiveness on January 1, that would be in place. So that's the year in front of us. On the technology front, Secretary Fontes was quoted in a newsletter called the Arizona Agenda yesterday, is talking about the desire to have the See the Money version, whatever, be more effective than the prior versions of See the Money. I am optimistic about that. The act, essentially directs the secretary to make filing under this available. And it also provides that the commission and the funding that comes through the new act is to pay for that. So now all of us have been through that before, a couple times in the last 8 years. So, but I really think that at this point, Prop 211 has, and we've already engaged a little bit with the cities on this. Prop 211 has implications for both for cities and the commission, and for filers. And so, if there wasn't critical mass over the last 10 years during which some Secretary of State was supposed to have built a system that was available to all filers in state, we're hopeful the critical mass is finally there, because the alternative is the cities will have to deal with Prop 211 issues that they don't want to deal with. The commission will have a harder time dealing with its enforcement responsibilities, and the Secretary of State's office, has a real opportunity here to I think start fresh, and there's a fresh opportunity to make sure that the fiscal concerns that are always going to be part of any secretary's decision making are alleviated, and we sort of start fresh with that. So that's my hope. I have not, the one thing I've not yet done, and partially because I'm not yet certain how the Secretary of State will want to orient his relationship with us on technology issues and through what channels, but I think we'll hopefully get a meeting together at a minimum with me and Mike and whoever the Secretary's office designates to lead on that, to get to where we need to get. I think that it's great that Prop 211 is effective now. I mean, there's a certain that's helpful in the sense that you may as well make it so. But as a practical matter, and the rules are not substantive in the sense of creating laws that don't exist. They're about implementing the law that's been set forth by the voters and creating a system that allows the commission and the parties here for the commission to have their claims heard and adjudicated. Right? We're not talking about making we're not talking about making substantive law. That's not really our role. It really never has been. We've always been about trying to create some, there's some gap filling we do, and in the case of the disclaimer, we will have to do some gap filling, right? Because we're directed to do that, but the principal driver of our rules has always been process. And then at the same time, but the technology piece is very important, because at the end of the day, if folks can't file or have difficulty filing, then it doesn't go. I mean, that's just a real problem for example, if you say to someone, look, you spent X number of dollars on, on a public media communication about a clearly identified candidate, but you can't file it anywhere, that's gonna be a real issue. And I'm not sure we'll get as much, we've done in the past, we've managed to sort of work around that when the system maybe didn't work so well with a kind of a PDF form and but this is not really that's not what the voters are asking here. The voters are asking to be able to look at this stuff and understand how elections are being influenced within, the boundaries of, the statute and the Constitution. So that's sort of the timeline.
Okay, I think it's safe to say that Proposition 211 is going to have a major impact on clean elections, whether it's the 5 of us or the 5 who are in office when this happens in a number of months. Who knows? But any questions from my colleagues on item 6, Proposition 211? Okay, thank you. Item 7, discussion and possible action on the following 2022 primary election candidate audits. Mike's going to make some general comments on this item. Mike?
Thank you, Mr. Chairman, Commissioners. Before you are 10 of the 11 primary audits. There's one outstanding that will be on the next agenda. The reason for that is simply we wanted to give the candidate a little more time. They had some things pop up right after the election and during the holidays, so we were just trying to accommodate them. But these audits turned out very well. There are some minor issues that were found, such as entering a contribution twice, entering the wrong amount for an expenditure, such as they entered $19 and it should have been $190, simple things like that. Those issues have been corrected and are being corrected as we speak. I also want to say thank you to Fester and Chapman, our auditing firm. They're exceptional to work with, great group of people. They do a fantastic job, and it is such a easy time when we're doing audits with them, because they've been working with us so long that we just know exactly what to do and how to do it. And I also want to say thank you to our candidates. They worked very well with our auditing firm. Anytime they had questions or concerns, we were able to get them resolved quickly and easily. Again, primary audits turned out very well. We're very happy with them. It shows that our workshops are working, and the way the staff handles things in terms of being available, email, phone calls for the candidates helps alleviate a lot of the concerns and issues that are raised. And so the audits and the campaign finance reports for that turn out well, and we're very happy for that. And with that, happy to answer any questions. And as always, as you've done in the past, if you decide you're going to approve them, you can do it as one block, A through J, if you'd like.
Okay, thank you, Mike. Any questions or comments from members of the commission?
Commissioner Payton.
Commissioner Payton? Yes.
I'm just happy that we have no issues considering what we've had in the past. I mean, obviously we are educating them well. I'm happy that the staff is doing such a good job, and that's we've had to spend a lot of time on, random, just when we did random audits and whatever. And I'm just glad we're auditing everybody and we have such a good result.
Good, very good point, Commissioner Payton. We have had problems in the past, and I think a big reason for fewer problems is the education program that we go through with the candidates. So thank you for those comments. Any other comments or questions from members of the commission? Are there any comments from anyone in the audience on this item? If so, raise your hand or signal the moderator in some way. Seeing none, I would entertain a motion to approve the audits identified in item 7 of the agenda.
Mr. Chairman, I move that we approve the audits identified in item 7 on the agenda.
Is there a second to Commissioner Chan's motion?
This is Commissioner Payton. I second the motion.
Thank you. We'll do a roll call on item 7. Approval of the audits identified in item 7 of the agenda. Commissioner Payton,
Aye.
Commissioner Chan,
Aye.
Commissioner Titla,
Aye.
and Commissioner Kimball also votes aye. The motion is approved 4-0. Thank you, Mike.
Thank you.
Item 8, discussion possible action on 2023 chairperson of the commission. Since we don't have Commissioner Meyer here, I hope that it's okay with my colleagues if we put this off until next month. Any discussion on that?
No.
Okay. My pages are stuck together here. Item 9, discussion possible action on commission meeting schedule, format, and venue. Item 9 is about whether we keep the current meeting schedule and format. We have a meeting in February already set up. Staff's thought here was that after 3 years, we may want to discuss if we stay remote, what our schedule should be going forward, similar issues. We know from the executive director's report, the boardroom at the main office is still a work in progress. Do any of my fellow commissioners have thoughts on how we should proceed with future meetings? Do we want to wait for Damien to be available? Any discussion on this?
This is Commissioner Payton.
Commissioner Payton, yes.
I mean, I think it would be good to go back meeting face to face. Maybe not for, until the boardroom gets fixed up. I mean, I'm the one, you and I are the ones that travel the farthest probably. But I think, I miss, seeing people face to face, and I guess I'm a little bit old school in that. But maybe in a few months, maybe if we can meet as a group when the room is fixed up.
I just want to say, Commissioner Payton, I agree with you. I much prefer the in-person meetings. I think it's a little frustrating that it's taking longer to complete this room than it took to build the pyramids, I think. And I think at some point, when we have a place to meet, it would be nice to meet in person. Commissioner Chan, any thoughts on this?
Sure. Well, I think you all know, I mean, I don't mind meeting in person. It's been really convenient for me to be able to meet remotely. But if the will of the commission is to start meeting in person, especially once our, meeting room is ready, I'm happy to do that. Regarding the timing of meetings or schedule of meetings, if we don't need to meet every month, or if we meet on a quarterly basis in the off election years, depending on what staff recommends, I'm happy to do that as well. I don't know if that's on the table, but I think, just making the best use of our and the staff's time. If that's a consideration, I'm happy to adjust our schedule as well. So that's all I have to say.
Commissioner Chan, I think I can't speak for Commissioner Payton, but it seems to me that if we do meet in person, forever we're going to have the option of audience members and commissioners who are unable or would prefer to connect remotely would still be able to. I don't think that we're ever going to we're doing away with that.
Okay. Sure. I appreciate that very much, that consideration. And frankly, I've been downtown a lot more recently with the transition, just kind of being there with the new team. And so it's definitely something that, would probably fit better into my schedule now, but and I'm happy to come down. If everybody's going to be there in person, I'd be happy to be in person. And I do recognize there's a difference. I mean, for me, remote works well, but there is a difference when you get to see people in person and be there in the same room. So.
Thank you, Commissioner Chan. Commissioner Tidlett, do you have any comments on this matter?
Yeah, I agree with all your comments. I think it'd be good to meet in person again. Thank you.
Okay. Thank you, Commissioner Tidlett. Tom, is that of any help, those comments?
Well, I take from those that, when we get the building up and running, we'll be taking a look at in person, and then like I said, everyone's absolutely right. I mean, I think that we have a wonderful representative from the General Service Administration who I think is pushing folks to get stuff done, but and obviously Paula has been on top of it completely, but it's everything from supply chain issues to, whatever. But yeah, no, I think that's the direction. And then I think on the timeliness of the meetings, in terms of that, I mean, I think that we met, whether it's quarterly or whether we just go every other month or something like that. I mean, I think that our plan from here will be at the February meeting, and Paul is still there, interrupt me if I'm wrong, but I think our plan from this conversation will be to try to lay out some proposed dates, maybe even through the rest of the year, instead of just the 6 months at a time, that try to capture what we're talking about in terms of, whether, maybe and it might be a little bit more of a range, like if we met every month, or if we met every other month, or if we met quarterly. And then with the expectation that at some point in there, we'll tie in the in-person process. And so that's kind of that's what I'm hearing as the director.
Yeah, and I think people are generally saying that they support monthly meetings unless there's no reason to have a meeting,
Right.
which
I mean,
is kind of what we've
yeah.
been doing.
Yeah, that's, Mr. Chairman, you're correct. I mean, that's been our we've never felt uncomfortable canceling a meeting when we don't have anything to present. So, I mean, that's fine too. So, yeah.
So at this point, you have no indication whether the facilities will be ready for the February meeting or not.
Tom, if you don't mind, this is Paula, Chairman, Commissioners. Mike and I Tom is correct about supply and demand and chain issues, but we're supposed to get trained on February 1st. So if Mike and I feel comfortable enough, we think everything works, including having the technology to live stream, which is important for us. And also for folks that still may need to attend remotely, we want all capabilities. If it's a go after our training, we will have in-person meeting in February, but that's based on that, those caveats. Otherwise, I feel I could, if not February, I think March is very doable.
Mr. Chairman.
Commissioner Payton?
Yes, I would feel more comfortable, maybe because I'm kind of involved in some things right now with my business, maybe doing it in March. That would give me time to make sure that I could get up there and so on.
Okay. Thank you. And thank you, Paula. We have a question from Ms. Knox, Tom, asking, what's the date for the February meeting?
February 20th, Mr. Chairman, Ms. Knox, it's February 23rd.
That's correct.
Okay, thank you.
And,
Any more comments on item 9?
And
Okay.
sorry, Chairman, Commissioners, this is Paula again.
Yes, Paula.
I'm almost with what Commissioner Payton said. March more than likely puts us in a better place to be well prepared and trained and everything, because the technology is what's important, and testing it, we'd rather make sure everything works than to just do a quick run, nothing works for us. It's really the live stream is what's key for us. So
Okay,
March is, I think, very doable, gives us enough time to make sure all the bells and whistles work.
okay. Okay, that sounds good. And we'll set the, in February, we'll set the meeting dates for March and going forward.
Excuse me, Mr. Chairman.
Yes,
Sorry, just so the record is clear, the February meeting will be held over Zoom, and then the March and going forward, we'll be looking at in person, correct?
that's the current plan, yes.
Yes, I just wanted to summarize that, so if someone was looking through the minutes, they could find it in one section.
Thank you. Thank you for making that clear. Okay, item 10. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date, or responding to criticism. Please limit your comments to no more than 2 minutes. Does any member of the public wish to make comments at this time? Let me just also point out, you can send comments to the commission by mail or email at ccec@azcleanelections.gov. Anyone in the public want to make comments? Ms. Knox, I see you raised your hand.
Yes, good morning. Oh, I'm good. I'm not muted, right? Good morning, Chairman, or Acting Chairman Kimball, and members of the commission, and Mr. Collins and other staff members. I'm glad to be back in 2023. I have mixed feelings about seeing all of you, meaning I think it would be great if there were new commissioners appointed, not because you all are not doing an amazing job, but because I think that the idea was that being a commissioner was not a lifetime commitment. So I do hope that the new newly elected appropriate officers will be eventually, maybe sooner, moving to nominate new people. I also just wanted to say that I personally, in reading through the brief, and I'm not an attorney, as you all know, but I was quite troubled when I read through the brief that is challenging proposition, I still call it Proposition 211, the voters' right to know law, because it seemed to me that a goodly portion of it was really challenging literally the existence of the Citizens Clean Elections Commission. And I found that very troubling, both personally, as well as on behalf of some organizations, although I'm not here representing anybody but myself. But I know that various organizations, as you all know, were very actively involved in creating the Citizens Clean Election Commission. And I found that whole argument extremely troubling. And so I guess all I'm going to say is that I will continue to follow what is going on. And once more information is available about the process that this lawsuit will take, as you said, Mr. Collins, about Executive Director Collins, about the dates and so on, I will try to bring this to the attention of some organizations I know, because I do think it is an issue that really seriously needs to be challenged. This idea that legislatures rule, period, I think is a troubling one on many levels. I don't want to get into this, not a political argument, a philosophical argument really about what is democracy and what are the role of different entities within democracy. But I mean, Citizens Clean Election Commission was created by the voters with all of its powers. And I think the intent has always been very clear as to what its role is supposed to be, separate from the legislature. So with that, I will just say, have a good day. And I will, my plan is to Zoom in with you guys in February. And thank you for explaining the date so I can get it on my calendar. And that is all. And thank you for the opportunity to speak.
Thank you, Ms. Knox. It's always helpful to hear from you with your very long connection to the commission. Thanks for your comments. Is there anyone else who wants to make comments? Okay, item 11, motion to adjourn. Does anyone want to make a motion that we adjourn?
This is Commissioner Payton. I make a motion that we adjourn this
Thank you,
meeting.
Commissioner Payton. Is there a second?
I second.
that motion.
Okay, I first heard from Commissioner Chan, seconded. So we'll call roll. Commissioner Payton,
Aye.
Commissioner Chan,
Aye.
Commissioner Tidla,
Aye.
and Commissioner Kimball votes aye. We're adjourned until February. Thank you.
Thank you.